Ladies and gentlemen, welcome to the Committee on Public Finance. We have one matter under consideration, that is the Sri Lanka Telecommunications Amendment Bill that has got clearance from the Supreme Court with multiple amendments suggested. Before we start, would you please identify yourselves for the record?
I'm Sumati Dharmadara, President's Counsel, Additional Solicitor General, representing the Attorney General with Deputy Solicitor General Mr. Manohara Jayasinghe.
N.D. Lattuahandi, Senior Assistant Secretary, representing Ministry of Technology.
I am Madhushanka Disanayaka, Director General of the Telecommunication Regulatory Commission of Sri Lanka.
I am Ruwani Gunratna, Secretary to the Commission of the Telecom Regulatory Commission of Sri Lanka.
I am Shamila Krishanti from Legal Draftsman Department, Assistant Legal Draftsman.
I am Indrajit Thandapangada, Telecommunication Regulatory Commission. I am the Director Competition.
I am Nihal Ratnapala, Telecommunication Regulatory Commission, DDG Policy and Planning.
I am Ganesh Murthy, Director License Management from Telecom Regulatory Commission of Sri Lanka.
I am KSM Vishaka, Deputy Director General Development of Telecommunications Regulatory Commission of Sri Lanka.
I am Sarat Kumara, Deputy Auditor General, National Audit Office.
I am Bindya, Senior Assistant Auditor General, National Audit Office.
I am Tushar Rodriguez, Additional Director General, Public Enterprises.
I am TDR Prabodhini, Director Acting, Department of Public Enterprises.
I am Sisira Henadira, Senior Assistant Secretary from President's Office.
Henadira. Right. Then the Ministry of Technology is represented by the Senior Assistant Secretary. Is that correct?
Yes, sir.
Right. The Secretary is unavailable today.
Yeah.
You informed us.
Yeah.
Right. Who is going to lead the discussion? Who will explain?
Honorable Chair, with your permission, if I may give some background to the proposed bill and outline the major amendments proposed in the bill.
Yeah.
So then and there you may be able to get clarifications on the proposed amendments. So.
Okay, Mr. Disanayaka, do you have a presentation or?
No, I can just explain it. Yeah.
Okay. First of all, let us just say that we are very happy that this is happening, because this amendment should have happened, I guess, 20 years ago. 96, the last amendment. Telecommunications is growing rapidly and changing the world and the future. So we have to not only play catch up, but I think the legal framework must provide a platform for us to plug and play in the future. So while I'll be quite honest, while it seems to have been an effort to update, I still think that there can be and there should be much more done to ensure that the legislation is future ready. So let us take that constructive criticism as something we need to keep in mind when we go through the discussion, so that perhaps we can add things even during the committee stage where we feel that it would be better to make it easier for technology infusion, because we also have a national digital strategy. And I think today is the beginning of the Digi-Econ Summit. So a lot of technology-driven stuff is happening. So let's keep that in mind, and when we discuss and when you answer, make a note of what you think would be perhaps meaningful, even at a committee stage, to bring it. Thank you. You can start.
Honorable Chair, so as you correctly mentioned, this amendment is coming after 28 years since the last amendment in 1996, despite the revolutionary changes in the telecommunication industry and the technological landscape. So there has been efforts to amend the bill since much earlier as year 2000. And it went to cabinet number of times and approved, but during down the line, it got stuck somewhere. So like this time, we understood the requirement of this amendment. And especially on the other hand, the government had the World Bank Development Policy Operation. So under the World Bank Development Policy Operation, there were a few items in terms of expanding the telecommunications infrastructure, connectivity, and ensuring the competition regulations, like competitiveness in the industry. So in that background, World Bank also identified the amendment of the Sri Lanka Telecommunications Act as a priority action under that World Bank Development Operation. And in keeping with the deadlines, last January we started, like we got together all documents previously approved, concept notes, the representations made by the industry, various parties in respect of the amendment of the Act. Then we tabularized everything and had several discussions with His Excellency the President, being the Minister of Technology. And we developed a concept paper in consultation with the World Bank. So World Bank was very generous to provide the technical assistance with the technical team, just to ensure that the amendments are in line with the international best practices.
Mr. Dissanayake, may I just interrupt you there? I mean, a criticism that has sort of been tossed around is that there were no consultations with industry and civil society. Is that correct?
Sir, if you like, we have a complete set of files, first instance, with regard to the Act amendment. Since 2000 and before that, even before that, there has been representations by the industry and the other various stakeholders for the Act amendment. On one hand, there were various discussions. Even I took over as Director General last August. I had a series of discussions with the industry, not only about the Act amendment, but generally with regard to all issues that were pertaining for a long time. So as a result, we were able to sign an industrial agreement with all mobile network operators in the country to solve every spectrum allocation disparities, irregularities in the contiguity of spectrum and connected issues. That agreement was signed, and there were a number of court cases against the TRCSL. So this agreement was filed in all those cases, and all those cases were either withdrawn or either settled. As of now, there is no court case against the TRCSL in terms of infrastructure.
So what you're saying is you have had extensive discussions
Yes.
with all the stakeholders.
Yes.
That means operators,
and consumers, and there have been now we have a separate compliance unit which handles the consumer complaints. So
no, you talked about the frequency, you talked about the spectrum allocation and contiguity and all that.
Yeah.
But the Act is much broader than that, right?
Yeah.
So my question is, have you had consultations on the broader sort of, let me use the word spectrum, of issues in the bill?
Yeah. So since 2014 there has been discussions. Even after I took over also, we had discussions on the potential amendments to the Act. But there is a certain part that as a regulator, like we are looking at an industry completely driven by the private sector with the impending divestiture of Sri Lanka SLT Mobitel. So in future it will be a completely private sector driven industry. So we are looking at a very futuristic way. So the regulator should have certain powers which industry might not like, but still we have to enforce the regulator to have to ensure reasonable competition and to protect the interest of the consumers in the long run. So however, the criticism of not being consulted not officially came to us anyway. Like we had extensive discussions, but in the newspapers and media I also came across such criticism.
Okay, let me direct this to Mr. Dharmavadana. Would you be kind enough to explain to us the gist of why this matter was taken to court and what the general observation of the court was and how you are going to remedy the issues that were argued?
Good morning, Chair, and thank you very much for inviting me to address this sub-issue. As explained by the Director General of TRCSL, the amendments to the Sri Lanka Telecommunication Act is being taken up to this stage after lapse of almost 23 years. And personally, I have served in 3 cabinet subcommittees. All these 3 cabinet subcommittees considered certain amendments from time to time, but that never saw, it was never sent to the Parliament as a bill. So I'm personally happy for the efforts what I also have done to develop the legal regime pertaining to the telecommunication law. Having said that, the matter was challenged in the Supreme Court by some broadcasting companies, television broadcasting companies, and the Media Guild and the Broadcasters Association. As the Honourable Chair is aware, allocating spectrum and regulating the spectrum covers both telecommunication and broadcasting. And the Supreme Court in the Sri Lanka Broadcasting Authority special determination accepted that the spectrum belongs to the state. And that is a universal acceptance. The spectrum belongs to the state. And the ITU has categorized Sri Lanka into Region 3. We have to follow the ITU guidelines when we are allocating spectrum. That position the Supreme Court accepted, but the broadcasters raised the issue, the 4 petitioners raised the issue that when the spectrum can be varied or withdrawn by TRC for technical reasons, a politically oriented decision will affect the broadcasters' rights. So that was the gist of the matter before the Supreme Court. Therefore, the Supreme Court considered that the clause 9 and matters pertaining to spectrum, including clause 20, can be amended, but the proposed amendments, even under the committee stage, the Attorney General intervened and we provided committee stage amendments giving certain checks and balances, especially when you are withdrawing or varying a committee spectrum, the TRC to permit the affected party to submit an appeal, and thereafter that appeal to be considered by TRC, and once the TRC gives its determination, giving a time period for them to challenge it in the Court of Appeal.
So the question here, Mr. Dharmavardhana, is you said broadcasters and telecom operators. These are, in my understanding, 2 separate groups of people, right?
That's correct.
Like broadcasters are TV companies, radios, etc. These are phone companies.
Yes.
So now, does this apply across the board to both these groups?
Absolutely correct, sir, because it applies to when you allocate the spectrum license are issued to both broadcasters and the telecom operators. May I be permitted to explain that when a spectrum is allocated, let's take a very small example, 1250 megahertz band, which we go through, which we hear in the radio. After 5 years' time, ITU may decide that is required for 6G operations. So the regulator should have the authority to withdraw, vary and allocate it. But unfortunately, the broadcasters took this position before the Supreme Court that the TRC is, the members of the Telecom Regulatory Commission is appointed by the Honourable Minister in charge of the subject of telecommunication. Thus, it's under a political control, and that will impinge the rights of the broadcasters to continue broadcasting. So the Supreme Court followed that, and that is why the Supreme Court had taken up the position in the special determination that especially the proposed amendments under clause 9 will have to be under a special, approved by a special majority.
So now what does it mean? So does it mean that the quote-unquote politicization of the board of the TRC, as opposed to, let's say, the Online Safety Commission, which is to be appointed by the Constitutional Council, then I would think that the TRC is a stronger and more powerful body. So when you say you need a 2/3 majority to continue to have the board appointed by the, if I understood you correctly, continue to be appointed by the minister. Is there some change you are proposing or?
No changes.
Okay.
Because the Supreme Court, even though this issue was raised by the Learned President's Council who appeared for the petitioners, Supreme Court took up the position that the existing law, the Act number 25 of 1991, have been approved by the Parliament, so therefore they are not going to touch that. So the structure...
That is the structure of the TRC.
It will remain as it is. But withdrawing frequency for even for technical reasons
can be challenged.
Can be challenged.
And it has judicial review.
In fact, we propose a judicial review. For that, they have taken up the view that withdrawal will not be possible, but they will permit to vary. So
like, let's go back to the example. You said 1,250 megahertz was given to radio.
Yes.
Now you said perhaps down the road it can be for 6G.
That's what.
Now say I am using 1,250 megahertz.
That's what.
Now when you say withdraw, that means I have to give up my 1,250.
Exactly.
When you say vary, it means something else.
Something else. So vary means what I explained to the Supreme Court was that 1,250 will be taken, but he will be given a frequency, a suitable frequency.
So to operate his radio?
Operate his radio.
Mr. Disanaga, were you planning to say something?
Yeah, no, if I may explain a bit of a background, like this was done in consultation with World Bank also, like as you correctly mentioned, like when you say the radio frequency spectrum, it covers both broadcasters and telecommunication regulation. But unlike the broadcasting sector, this telecommunication sector is very dynamic and it keeps changing. So that's why we wanted some explicit powers under the Act to withdraw, vary or whatever, because like from 4G, 5G, 6G, it's been upgraded and you can't use the same band for the same technology. It may be the next band. So we might have to, like, it's very dynamic and operators, so we'll have to
So let me ask you this question, Mr. Disanaga. So broadcasting license is not touched here, no?
Not touched here at all.
That's a separate
That's
thing
why,
altogether.
sir, I had
a broadcasting bill.
Yeah, I had a discussion with the Broadcasters Guild also. So they are, unlike the telecommunication operators, like let's say telecommunication operators completely depend on the frequency license issued by the TRCSL. But the broadcasters, they have a dual protection kind of. They have a media license issued through the Ministry of Media under the Sri Lanka Rupahani Act. And they have the frequency license issued by the TRCSL. So they are they are anyway protected.
So, all what I want to clarify is these are two separate licenses.
Yes.
Right? This doesn't really sort of overstep on the broadcasters.
When you say the radio frequency spectrum, it will include both broadcasters and telecommunication industry.
Because without RF spectrum, broadcasters cannot operate.
Cannot operate, yeah.
So the spectrum is given to broadcasters as well as
telecommunication operators, yes.
Right.
But different bands.
Right. So coming back to Mr. Armadana, is there anything else? I just wanted the gist, not the whole idea. Yeah.
So one of the salient features which was introduced in the recent amendment was to introduce a mechanism when allocating spectrum. Therefore, the competition-based methodology will be adopted when we are allocating spectrum.
Yeah.
However, when we look at the developments in India, where the Bharati Airtel challenged the decision of the government of India to allocate spectrum, there was an issue that the best methodology proposed by the government of India was to auction it, but the Indian Supreme Court held that the auctioning may not be the best methodology because the cost of the telecom operators cost after paying a very heavy amount to the government will be passed to the consumers. Therefore, we suggested that to follow the UK Ofcom methodology to go for the administrative decision as well as to go for the auctioning.
So what do you mean? Ofcom means is administrative or auction? Can be only one?
No. So when you go on a cost-based methodology, they can put a price tag for the spectrum. Therefore, the bidders will not go beyond that. But if you make it auction, the most financially sound company will put a very high bid, but invariably that will be passed to the consumers. That was the position taken up in India.
But in the rest of the world?
The rest of the world, especially in Singapore, at certain times they have gone for the auctioning, certain times they have put a price tag. Nobody has, because if we by statute, if we fix it to say only auctioning, then the TRC will get fixed. So we'll have to give us some leverage for them to consider the market forces and take a decision.
But what is the generally accepted rule?
The general accepted rule is to go on the cost-based methodology.
Globally?
Globally.
Is that what the World Bank also suggested?
I was not part of that discussion.
World Bank was suggesting to go for a competitive based methodology, but they studied the various aspects as well as our inputs as well as the best practices of the other countries. So there were few options, either to go to the administrative basis or to completely to a competitive based methodology, or either a hybrid method to allocate certain frequency under the administrative basis and beyond some point to have an auction among the operators. So there is no accepted rule as such. It depends on the market.
But then what is your rule? Does this act doesn't specify a rule?
Up to this point, it has been administrative basis.
Wasn't there any auction? Was there an auction?
Sometime, for the 4G, no? One time. Only one time. For the 4G, no? 4G, yeah. Only one time for the 4G.
So it is interesting because you say you want to create competition.
Yeah.
And now you say you want to give it administratively. So there seems to be a conflict.
No, we don't say that. Yeah, you can explain it.
May I explain, sir? So on this particular point, ultimately a committee stage amendment was proposed by the Attorney General to go based on a competitive based methodology, which the Supreme Court has agreed.
So there is going to be competitive.
Competitive based
methodology.
methodology.
What is the competition you are going to introduce?
So that has to be promulgated by regulations which will be under the parliamentary supervision.
Okay, good. So which means then the DNA of it will be competition.
Absolutely correct.
It's not an allocation by an administrator.
No. Not on ad hoc basis, because competition based methodology. So the Supreme Court in its special determination has stated, instead of minister making rules, to make it through regulations, then the same will be placed before the parliament and it will be under the parliament supervision.
Chair, if the determination says like that way, then since the AGS department undertaking, we can proceed and ensure that there is no we are sure about that we are abide on the determination.
Correct.
We can go ahead with the proceedings.
Yeah. So from what I read here, what it means is that multiple places the Supreme Court has determined that instead of rules, there must be regulations.
Absolutely correct.
Which means instead of the TRC making those rules, it has to be approved in Parliament.
Yes.
Under
parliamentary supervision.
So most probably, I believe that when it's come to the amendments, you will be suggesting the necessary amendments according to the Supreme Court determination.
So I mean, because we are still in the background, because we want to go through this thing. Now, just to get a clarification. Now, let us say somebody wants, I don't know what frequency. Let's use the same frequency, 1250 megahertz.
Yes.
1250 megahertz frequency. So there is only limited spectrum, right?
Yes.
Now, that limited spectrum, 3 people want.
Yes.
Okay?
Yes.
So, based on this legislation, do you have a basis upon which you will pick 1, 2 or all 3?
For that, they will have to first promulgate regulations.
Which you haven't done.
Which we haven't done.
So the regulations will be
placed before the parliament. But the regulations will have to be on competition-based methodology.
Yeah. Mr. Disana, you have anything to add to this?
Yes. So under this aspect, like we have been working with the World Bank, and we did a public consultation on the 5G the spectrum assignment methodology. So now the document was published for public consultation. That was concluded with the inputs of the industry. Now World Bank consultant has finalized the spectrum policy and the draft rules as well. So with the amendments, once the amendment gets through, we'll be able to approve that, and then that will be rules, regulations made by the minister under the act. And
competitively determined.
Yeah, so there are two aspects: competition regulations and the spectrum assignment methodologies.
So there is no, so which one you don't know?
No, competition regulations means to ensure the competition among, that is not with the spectrum, that ensure.
No, I mean in the spectrum.
A spectrum, yeah. Spectrum, yes, competition based, the rules are ready, so we'll
competition
be. Yeah,
based.
yes.
Okay, right. So then, so that's the gist.
Yes. Market competition and the frequency allocation. Yeah.
Different areas.
But
we are
frequency
talking
allocation is
about
on
the frequency allocation. We've been discussing on spectrum because there is market dominance criteria here now, and we want to get to that also. So basically the gist is to create competition, provide a platform for new technologies to come in, and because it is going to be completely 100% private sector driven, for the TRC to have an authority to ensure that this industry is regulated appropriately. So those are the three things. Is that correct?
Yes, sir.
Chair, I just want to raise a question. I could not.
Just one moment, Honorable Raghavan. We are giving them the opportunity now to sort of, we were discussing the background.
All right, okay.
Right?
Okay,
and now we can go through this. I don't know, I mean, this is a huge, 200 pages.
Yeah.
I don't want to go through all of it.
Yeah.
But let us go through the main points and also the amendments proposed by the Supreme Court, so that we are sort of comfortable in proceeding.
So if you could make the salient points highlight in relation to, then we can revisit those points that are being contested or in not so clear gray areas. No, I think that's
members, there are two ways in which we can look at it. One way is to go through the sections, and if there are no issues in sections, we can just proceed. Another way is to look at sort of themes and issues.
Honorable Chair, so if I may suggest, because there are many clauses, amendments, but we have a certain set of salient amendments. The other amendments are consequential to those amendments, kind of like cosmetics and other, like to give effect to the change of words and all.
Okay.
So if I think
please go ahead.
Yeah.
Please go as planned.
where there are structural changes, you have to present.
Please go ahead.
May I suggest to go through clauses by clauses, so therefore we can take a.
අපි suggest කරන්නේ important structural changes
only for the main.
Okay.
One of the clauses challenging before the Supreme Court was clause 8 with regard to the proposed section 9A2.
Yeah.
At that juncture we suggested a committee stage amendment. The Supreme Court made a determination in the special determination that instead of the word may, and to insert the word shall, and to bring a committee stage amendment as follows: the Commission shall give any operator or provider who is the subject of an investigation commenced under subsection 1 an opportunity of being heard and of producing any documentary evidence. So we are comfortable with that determination by the Supreme Court.
I'm sorry, Mr. Amadana, this is section 9.
This is in clause 8,
8.
proposed section 9A2.
Which page?
Today, no, it's not in the bill. It's in the what Lanka sent a 65-page document.
No, that's a determination.
That's a determination.
That's a determination. I'm now referring to the bill.
Bill. You're referring to the bill. Page 5. Page 6.
Page 6.
Okay.
Correct.
Yeah, page 6. So in that 9A within brackets 2, the Commission may give any operator or provider. Instead of word may, the Supreme Court suggested to use the word shall.
Right.
Are we on the same page?
We are on the same page. That's a technical matter.
That's a technical matter.
Okay, so if there is something I need to ask you in section 6, can I go ahead and ask you?
Please.
Yeah, because then otherwise we will not be able to go back. In 6 you say, clause 6, section 8 of the principal enactment is hereby amended by the substitute word every operator and provider.
Yes.
Now, does it mean, this is a technical question, so does it mean every operator and provider must henceforth get a license?
The DG will explain the technical part of it.
So now, under the present act, we had only two main licenses. Under section 17, we had telecommunication system license, and section 22, we issue frequency licenses and other vendor licenses. Now, in this amendment, we are introducing three more licenses types. One is for the infrastructure service providers to have infrastructure development, passive infrastructure development. So independently, we are introducing a license for the infrastructure developers. So that is a recommendation of the World Bank also. The second one, we are introducing...
So in that say infrastructure means like a
towers, yes, basically so towers or fiber networks.
Yeah. Then what about fiber networks?
Yeah, everything. So that is for the expansion of the networks and opening of the industry. So that is a very progressive one, which is practiced in other countries also.
There will be new providers for sort of say underground cables.
Yes.
Does this cover the offshore cables?
That is another cable landing station license. It is number 3. It's a different one. That's a different one. So there are 3. First one is the infrastructure service.
Inland infrastructure and offshore.
So they have a big section on cable landing station.
Yeah. The first one is the infrastructure service provider license. Second one is the telecommunication service provider license. Like let's say, for example, like satellite-based internet or whatever, which is beyond the conventional, like normal telecommunication services.
Starlink.
Maybe Starlink or whatever the satellite-based or whatever new technologies. If it is telecommunication-based service, different license, and for a license for the cable landing stations. So this, I mean, the clause you referred, sir. So now the previous act, it says only the system, so we have added the provider. So provider means under the new license, it will be infrastructure service provider or a telecommunication service provider. So just to include the scope, only those amendments have been proposed.
So, with respect to Honorable Vitana's comment, that we need to make sure that what we are talking here. I have been in this same discussions when Honorable Mangala Samaraveera was liberalizing the telecom. Now, are we also covering our satellite rights under this? That has to be completely told to the nation and the state that we are not doing that. We have, I think, as I understand, I'm not a telecom engineer, but there are about 6 satellite space that belongs to Sri Lanka and our territorial waters. So, being silent is not a good thing. We need to at least bar them, the satellite providers.
Honorable Raghavan, I think from that...
Silent means you can agree or disagree. Ne? So we have to bar it out.
Honorable Raghavan, I think it's already covered.
Yeah, please.
In terms of the main Act 25 of 1991, there are, as the DG explained, there are 2 kinds of license what we can issue. One is the telecommunication system license in terms of section 17 and section 22, the frequency license. Without a frequency, you can't run a telecommunication network or a broadcasting network. I think we are on the same page. Even with regard to the satellite, we belong to the region 3 of the ITU region. So the satellite frequencies are set out by the ITU in terms of the ITU guidelines. In Sri Lanka, to my knowledge, the TRC has not issued any satellite operator license. Am I correct? We have not issued. We don't have. But in terms of the external gateway operator regulations, in order to downlink and uplink a satellite, under the regulations which was brought when the international gateway was liberalized in 2003, Honorable Chair may recollect, at that time, when you want to downlink and uplink, you have to take a license. You have to take a license. But
those are called external gateway operator license.
Absolutely correct.
EGO license.
EGO license. For them, when you need to uplink and downlink, you have to get a license. But any telecommunication apparatus under the main act, you have to get a license. If you are downlinking or uplinking, that's a telecommunication apparatus. Therefore, you need to obtain a license.
Yes, sir.
We have been, for last 8 years, we are having a satellite link with India for education to Sri Lanka, which we are not used. We are not used that for entire Sri Lanka to cover for education purposes only. Because of this satellite thing, we are not clarified. So, when we are having cloudy areas like that, being silent is not a good thing. So I want you all to make sure, the committee to make sure also, that we are ruling out that this is, we are talking only on the non-satellite area. Whenever satellite operation is needed, there needs a separate licensing process in terms with the international and our regional agreements.
If you are talking about satellite-based internet, that is covered. Yeah.
I think from the what you said, the scope has widened.
Widened, yeah.
When it's come to the previous law on the
No, I think we are a little bit confused. One is like we have this VSAT type thing, no? That is not what you're talking about. Everybody has a dialogue VSAT. That is not what you're talking about, no? You're talking about?
Honorable Chair is promoting brand names.
Yeah, we'll avoid brand names, no?
Sorry, you're talking about, he's saying, downloading from Indian communication. What?
Satellite link, we have 6 spaces, but this satellite channel that have been given.
So that is like that SLEDA and all what you're talking about?
Yeah,
those
SLEDA and all other areas that you have to cover. But this is a different issue. I know we are different issue we are talking about.
But is it
But I want to
this?
make sure that as a member of the committee, that we are not blindly doing this, but we are ruling out those possibilities and we are signing for the correct thing. Right?
No.
Yeah.
No.
No. See, I think in the north and all, there are television channels that are actually broadcast from South India. They are broadcast from South India and watched in, say, the north of Sri Lanka.
Yeah. So, as of now, we have given license for cable TV operators and all. So, they are already governed.
This has nothing to do with this, no?
No.
Okay, right. Go ahead. Then on this matter, what about unified licenses?
I will ask my direct license management to explain it in detail.
What is a unified license? Is the world moving towards unified licenses, or is the world moving away from unified licenses?
World moving towards the unified licensing. In case of unified licensing, we also got one ITU consultant, and we have prepared the framework, and based on the framework, now we have prepared the license document. It's a template, and now...
What is a unified license, please?
It is actually a combination of fixed mobile service. Now presently we are going to issue unified licenses to fixed and mobile operators.
No, but then what you are trying to do here, I thought, was to break. You want to give infrastructure licenses, various other licenses, no? Right? Now, when you say unified, does it mean all-encompassing license that one provider can operate infrastructure, it can operate mobile, it can operate fixed? Does it happen like that? Or, my question was, where are we converging towards? Because at the beginning we said we have to be future ready, right? We have to be future ready. Where is the technology moving? Is unified license a thing even today? I mean, are we talking about fixed line licenses? Is that something that, who's opening fixed lines?
There are two types of convergence. This one is the infrastructure convergence, the other one is the service convergence. normally we talk about the service convergence there, which is the most important one, because previously the infrastructure is more or less restricted to particular service. So if you take in the 90s, if you deploy a network, it can only give a particular service. If it is telephony, it's telephony, but data cannot be transmitted over that. But now,
please go ahead. It's an emergency call, but please go ahead.
Okay. Then with the technology development, now the latest infrastructure, many services can be deployed over the latest infrastructure. So if you are restricting the service, when a telecom operator deploy a network, and if we restrict a particular service, we cannot maximize the utilization of that network. That is why the unified licensing is coming in. Because if you deploy a network, we can give telephony, data, everything we can deliver over the same network.
See, I'm not a technical person, obviously. I'm just asking the question to make sure that you all are ready. So if that is where the world is moving, if unified licenses are what needs to be given, that this piece of legislation allows for unified license to be provided to people who need them.
Yes, this is ready, and we are
actually it's a very progressive movement. Like, we are not restricting in terms of technology, so we are moving towards technology neutrality. So under that concept only this unified licensing comes in. So but infrastructure licenses we are giving independently for the infrastructure development. So this unified
like
licensing
for network, fiber provider.
Yes.
So you'll have a separate license for a fiber provider.
If there is an application, we can issue it. Yes.
If there is an application, so you can really define.
Yes.
Okay. All right. Go ahead.
Honorable Chair, may I?
Yes, please.
The next issue which came up before the Supreme Court was with regard to clause 9, top page 8 of the bill.
Yeah.
At the outset itself, the Attorney General suggested a committee stage amendment, 2 committee stage amendments. Out of that, the Supreme Court held that if you go through clause 9 under 1 capital A, subparagraph A, to say divide and allocate any part of the radio frequency spectrum into number of bands it thinks appropriate and specify the service or purpose for which each band may be used, the Supreme Court has given permission to bring the committee stage amendment as follows: frequency spectrum into number of bands based on the International Telecommunication Union policies and guidelines or international best practices in the best interest of the efficient management of the frequency spectrum and specify the service or. In addition to that, sir, so if I explain that...
Mr. Damodar, we don't really need to go into great detail of all the amendments.
Fine.
Because this committee's objective is not really going into all those.
Yes.
This committee's objective is really matters related to public finance by, broadly. But it has been sent to us because of the relevance in terms of licensing and related matters. So we trust that you know exactly what the Supreme Court told you to do and that you will abide by those instructions. Just give to us.
Judges would have seen into other areas which we are not entitled here.
Precisely.
For instance, these documents had to be vetted by the national security and the data ownership. And once the license are given, those data that they operate, the ownership of those data and what purpose they use. I'm not going to raise those questions here because the courts would have, I hope, had the wisdom and the knowledge to question all those people who brought this bill in front of them.
Yeah, so we asked them what the gist of the court cases were before you came, Honorable Sir, and they sort of explained to us, but they didn't mention anything about that particular subject.
This never arose with regard to the data security and those issues. That was never challenged. Yeah. So let me tell you, what we are more interested is in the
the public finance aspect, the competition aspect, the equity and fairness in the market aspect, those are the ones, you know. So you stick to the specifics of the law that you are better than us.
Chair, I think since there is a huge accusation that even though we are not as a legislative members of the legislature, that we are not abiding towards the Supreme Court determination.
Yeah.
I think Mr. Sumati is doing a nice job, because anyway we have to ensure that whatever the Supreme Court suggested, we are abiding to the Supreme Court.
Absolutely.
And we are making the changes.
No, absolutely.
So I don't think we don't want to go to the details. But anyway, we can ensure from the CoPF, whatever the Supreme Court has given a pathway to us,
Correct.
we are abiding on that, because previously there was a huge accusation that even though once the Supreme Court determination, the changes suggested, even though that we are not abiding on that. So this is a good example that we are ensuring whatever the determination,
But
whatever
we've known
changes
Mr. Dharmavardhana
giving-
for like decades, and we know his
So we are
professionalism.
ensured to the nation, even when it's come to the changes, we are doing changes in the committee stage.
Yes.
Honorable Chair and Sirs, thank you very much for kind comments. May I be permitted to state that yesterday I had a discussion with the Director General of TRCSL, and I instructed the DG that we should abide by the determination made by the Supreme Court.
Yeah.
There are only two areas which the Supreme Court has specifically stated that the matter should be re-gazetted, and my suggestion to the Director General was to leave that two sections out and to proceed with the committee stage amendments permitted by the Supreme Court, keeping in line with the provisions of the Constitution. Any committee stage amendment cannot change what have been brought before the Supreme Court.
Got it. But what are the two areas that have been regassed? Yeah.
Yes. So these all what the Supreme Court had major concerns is only with regard to spectrum matters. Nothing else. The other matters are, they have accepted the Attorney General's suggestions pertaining to committee stage amendments. The Supreme Court, at the committee stage amendment, the Attorney General brought a proposal, a committee stage amendment was proposed.
To which section?
To clause 9, to introduce a new section as subsection D, that is to vary the service or services or purpose for which such radio frequency has been assigned from time to time. That the Supreme Court decided that if the Parliament desires a proceeding with the said committee stage amendment, again we have to gazette it and permit the Supreme Court to exercise their jurisdiction.
So what do you plan to do?
So for the time being, because as I explained to the Honourable Chair, these amendments are coming after lapse of almost 30 years. The main act was brought at a time Sri Lanka was in a copper world. Today we have moved to the internet, regulating the internet and Wi-Fi using a legislation which was designed to regulate copper world.
I understand.
So we have to proceed with the Supreme Court determination.
Yeah, but you're going to drop those two, so you're not going to regassette them.
No.
But you're happy with what the outcome is going to be?
At the moment, we are happy, but as I...
Is the Director General happy? We have to ask him. No?
There was a small concern because under the current act, we had the powers to manage the radio frequency spectrum. That was a very broad but very concise section. So under that, we exercise this power already. The vary the service, for example, like let's say we assign a particular band for 5G. With the development, we say, okay, now this band we have decided to allocate for 6G, if it is technically capable. So we'll vary the services to the band. So we have been exercising this power throughout without any issue. Sometimes there were disputes and gone to courts with regard to the allocation, the decisions, not varying, but the decision we took, like not the authority. So authority was never challenged. But the decisions were challenged. Okay. But now anyone can challenge the authority, because now during the World Bank consultations, they wanted this section to be very explicit, just to like expand the horizons and make it more clear. And then only they proposed those sections very explicitly. So now anyone can challenge the authority saying that, okay, this amendment was brought forward and Supreme Court determined as such, and now you don't have the authority to vary the service. So that might arise. That was the only concern, but still, as the additional big concern, but the additional Solicitor General mentioned. Yeah. It will take much longer time to gazette it.
How long will that be if you have to re-gazette those things?
So we have to submit again to the cabinet, then gazette it, and again 7 days before presenting in Parliament. So after presenting in Parliament, we have to again wait for 2 weeks.
Okay, if it timing is the issue, because this is very sensitive area, Chair,
Yeah.
and I confess to say. Yeah.
So I am willing to make the call since
May I suggest a way out, because the time factor is also important and the markets are sensitive, and then we are walking in a kind of a cloudy election area. We can go ahead with this, but subsequently the expert panel has to give some kind of opinion, because this is sensitive area. Now, if the authority been challenged either directly or indirectly by their determination points, we do not know where this would lead to. Now, honorable courts had enough time, but out of the 15 judges, they would have had their own consultations about telecom engineering and all to give this idea. So, without stopping the journey, we will approve this, we will go ahead with this, but subsequently, the Sri Lankan national experts had to give us a kind of a paper on which direction they should go on.
Okay.
So this you are referring to 9(1) ABC, right?
Yeah. May I explain, Honorable Chair? What we wanted to do was to vary the service or services for purpose of which radio frequency has been assigned. As I explained, a small example, frequency 1250 is required for 6G, then we should have the power to vary. So now the Supreme Court has allowed us to vary based on International Telecommunication Union policies and guidelines or international best practices. So there's a way out in it.
That's okay, no?
That's okay. In addition to that, may I be permitted to enlighten the original Act Section 10(1). May I be permitted to read it? The Commission shall be the sole lawful body in Sri Lanka to manage and control the use of radio frequency spectrum and incidental and restricted emissions, matters relating to geostationary satellite orbit, and shall have the power where it deems necessary to withdraw or suspend its use or prohibit any such emission. So
you are reading out of page 9.
No, this is reading out of original.
Old one. Existing provision still has given more authority for TRC, but to prohibit, withdraw, suspend, or prohibit such emission. So therefore, if a person is or a company is misusing a spectrum, TRC still has the authority to withdraw, suspend, or prohibit such emission, not the spectrum, the emission. So
meaning the usage of
it. So therefore, I don't agree that even though TRC has concerns that their power had been limited.
Yeah, but let me ask you slightly.
Just 30 seconds. DG, if you read the bill, page 9, 10.A, capital A, Hindu 1, the Commission shall be the sole authority vested. Then it goes on to say, with the powers to manage use of numbers, names, codes, and identifiers. Does that not cover your...
No. May I explain that?
No. DG is concerned about it?
No. Under the current act, there were no provisions for us to govern the numbering. Although we have been governing, we have the national numbering policy, we give approval to allocation of numbers. We didn't have powers under the act. So that's why we are introducing a new section to have it explicitly under the authority. So that is separate. It is not connected to that.
Yeah, because I'll tell you a practical example, Honorable Raghavan. In most countries, emergency number is 3 digits. Ours, we have 19904 digits. So ideally, it should become 3. So I don't know why there is, but these are things that you can talk about into the future. But my question was, you said about emission.
Yes.
So emitting a signal in some particular frequency band.
Yes.
Now what happens now? Everything is going to be emitting signals now. IoT, smart homes will be emitting signals, cars will be emitting signals. I'm just asking, right? So if I have a Tesla, it is going to be emitting all kinds of signals all over the place. So I'm just asking.
Honorable Chair came out with a very pertinent question. That type of frequencies, the technical jargon will be explained by the engineers, but under this act there is no necessity once they, by regulation, once they declare for you to take license for frequency. For example, let's take a microwave equipment inside one of our homes, which emits a particular band of frequency. Those are exempted. So that was, in fact, that was also challenged before the Supreme Court. Yes. I had to take a lot of pains to explain.
So, but then we are asking all relevant questions then.
No, waves are different. The grade 8 science classes, no, waves are different. Alpha, beta waves are different. So, what we use.
No. We are talking about like for instance, garage doors and all.
That's
they
correct.
have particular frequency.
Category.
No. So they are all within the RF band?
Absolutely correct.
Yeah, it is all within the RF band. So, I mean, RF band goes from like 600 to like 10,000.
Like our hearing and other sound systems.
Correct. So, what they are saying is they have the full authority to manage the entire RF.
Entire RF and this type of RF bands, they will be exempted from license.
Yeah, but you still have the regulatory authority, so you exempt them from regulation.
Exempt කියලා decision ගන්නෙත් ඔයගොල්ලෝනේ.
Yes.
අපිනේ ගන්න ඉතින් අපිට authority එක තියෙනවා ඒක පිළිබඳව කියන්නේ.
හරි ඊළඟට.
So therefore we decided the clause 9 we will leave it, park it aside for the time being.
Okay.
Can I quickly run through the salient other issues?
Yes, please. Yes, please.
So if this is that import or a reject, while going with this process as an amendment, you all are hoping to bring it?
No, as Additional Solicitor General mentioned, we have enough powers under the current act also which are not repealed. I just had a concern because someone might challenge in the court, so that was the only concern. But still, we have already communicated our concurrence to move forward with
your lawyers will have business now. Okay, go ahead, please.
With regard to the competition,
yes.
One of the salient features introduced
clause what? Section what?
Section 1 is to go for to do investigations and to find out about the anti-competitive methods, which was challenged before the Supreme Court, but Supreme Court has approved the whole section without any changes. So TRC will have more powers to declare dominant operators and then to control the dominant status by conducting investigations. So these are very good new features.
You know, we have got a note from a telco operator, and what they are saying is significant market power. Is that what you're talking about here? Why do you want to control the emergence of significant market power as opposed to regulating the abuse of significant market power? Because the argument is, you need to create that, that gives them technological edge.
May I explain, sir?
Yes.
Unfortunately, this is, I think, we have come to a very good point, since the learned honorable members are very keen on this area. Pertaining to the mergers and acquisitions, there was a mechanism to regulate it under the Fair Trading Commission Act. And the Fair Trading Commission, the main Telecom Act was linked to the Fair Trading Commission Act. The Fair Trading Commission Act was abolished, and thereafter the Consumer Affairs Authority was enacted by the Parliament. However, we have failed to bring a law in Sri Lanka to control the mergers and acquisitions. Telecom is a completely liberalized industry under the WTO GATS Basic Telecommunication Agreement. And now we can see a trend has come forward where the mergers are taking place in the telecom industry. Therefore, emergence of a significant market power will be detrimental to the consumer interest. That is why when the TRC was very keen, the Attorney General gave the green light, we should control the emergence of a significant market power. A telco company who is eyeing to purchase another telco company may be having concerns with regard to this. As the DG explained at the beginning of the discussion, we are having a completely liberalized environment. Unfortunately, in the main act, if you look at, go back to the 1991 Act, the mergers and acquisitions to be dealt under the Fair Trading Commission Act. And today we don't have a Fair Trading Commission Act. Parliament in its own wisdom brought the Consumer Affairs Authority Act. At that time, there was a discussion in the Parliament and in the Cabinet to bring a new law to regulate competition.
The competition commission is coming, no?
That's what. So until
it's coming in the economic transformation.
That's what. So until such time, this lacuna has to be addressed, especially in the telecommunication field.
Got it. Now, let me ask you a technical question.
Yes.
How do you measure significant market power?
DG.
Director Competition will answer that question. There are a few measures.
Yeah, with the support of World Bank, so we are developing regulations to define the significant market players. Basically, we are planning to do a market research and identify the significant market power operator. And basically, with that draft regulations, so we consider that over 30% market share having some operators, we consider that such type of operator as a significant market power operator.
What is the current breakdown of the market? If you look at the mobile or if you look at the total thing together, I don't know how you measure
Yeah,
it.
if you get mobile separately, so one operator having close to 60%.
Dialogue.
Yeah. And
Okay.
then the Mobitel has about 26%. And the Airtel and Hutch has the balance remaining.
But wasn't there a merger recently?
Yeah, the Dialog and the Airtel merger is happening.
So they will have what now after the merger? How much?
It goes about
70.
Close
No,
to
60,
70.
60
Close
plus.
to 70. Yeah, 60 plus.
Yeah. Oh, so if it is 60 already Dialogue, and then you have Airtel 5 or 10, I don't know how much.
Yeah,
so they are
about-
very significant player.
Yeah.
So you monitor this just based on number of connections, or what is the way in which you monitor?
There are several criteria we can use. One of is this number of subscriber, another one is the revenue number of. So the revenue as well as the as per the regulations, you have to consider the infrastructure, number of frequencies allocated. There are a lot of criteria to define this market share.
What is the internationally best practice used? What is the international best practice? How do you measure dynamically the market significant market power in the telco sort of sector?
So basically, there are some indicators to define the level of the competition. HHI indicators.
You use HHI?
No, so with this regulations, we brought this HHI for this.
Okay.
Now we are in the process of, like with the World Bank consultation, these competition regulations comes in, so those have been accommodated.
So those are very good. I mean,
Yeah.
they're very progressive.
So
I mean,
now,
that's the world over.
Yeah.
What is called Herfindahl-Hirschman index.
Yeah.
Yep.
The thumb rule is to have minimum 3
Yeah.
players, because 30% that is.
So
Because the bipolar competitor will always create, now this is what the Indian market has come out with, no? Of course they are a federal state, so they have state regulations separately. But elsewhere, like for instance, a larger country like Canada and Australia, so they keep asking minimum 3 players so that there is not bipolar competition, it's a multipolar competition then.
For these competition regulations also, since January, we followed a very consultative process. We published a consultation paper and all inputs from the industry were like we obtained, and those were analyzed by the World Bank consultant. Thereafter, we formulated the draft rules, and now it was also shared with the operators.
Yeah, but then I have a question, I have a fundamental question. Now let us say currently one player is 65%. Now that's not emerging market dominance. It has established significant market power. Now, are you going to try to reduce that, or are you going to make sure that they don't abuse their significant market power? And the question has a second issue, is if competition is your sort of mantra, do they really have to do you really have to approve every tariff package, or should you sort of forbear in the market, let competition determine what tariff packages they ought to effectively compete in the market?
Sir, with regard to that, may I answer? The tariff forbearance is permitted in terms of the new amendment. However, that was challenged before the Supreme Court. We produced certain articles written by Professor Rohan Samarajiva and the Indian position. Even though it was very surprising, and I may take the liberty to inform the Honorable Committee, even though the broadcasters came before the Supreme Court, they were talking about tariff forbearance. Nothing to do with the broadcasters. I am very candid and open about it. We took a lot of pain to explain to the Supreme Court. In the special determination, the learned, their lordships have mentioned about the Professor Samarajiva's article, and they have approved to proceed with the tariff forbearance.
So that's good, no? That's forward looking. That's good. I mean, you need to regulate if there is no competition. If there is competition, why do you want to put your finger in this? I mean, you have to have light touch type of regulation in this. You don't need to go hard at it. So does it now mean that tariff packages need not be approved, every single tariff package by every operator need not be approved by the TRC?
After the amendment is approved by the Parliament.
So that is a major step forward, I think. I don't know. Do you agree, Mr. Nisana? You are looking.
No.
So I see the very rare occasion where the chair agrees with the presenters, right? And the chair is in a jolly mood also after.
No. I must say that these amendments were like with the World Bank also. They were very progressive. Like actually, we were very, to be honest, we were focusing on the telcos. To our surprise, broadcasters came in.
No, one area is that we can be, as a nation, be happy about is our universities and those who have come out of our universities gone abroad, and this IT sector and telecom sector, we are par with the regional knowledge. Unlike our sea. The sea order now, this Pearl Express report I am reading, we are just probing in the deep darkness, like as far as sea law concerned. So therefore, I would suggest that if there are no major concerns,
I'm glad. Let's move on.
Yeah,
I mean, I'm glad that you make. So the whole point is this, no, Honourable Member, this is going to be technology driven. The growth in this country is going to come from technology driven growth. So we have to have legislation to provide for that. That's my only concern, whether we are in government or opposition. Please go ahead.
One of the other salient features was introduction of new sections under the Telecommunication Act to safeguard the submarine cables. As the honourable members are aware, the new world war will emerge with the attack in the submarine cables, and it has happened in the Red Sea. Therefore, there will be a committee consisting of the DGTRC, the Navy, Coast Guard.
Yeah, we saw that.
Yes. Only issue is the Supreme Court was not happy with regard to the declaration of zone was permitted by the Supreme Court, but they were not happy with section 22, the power to make regulations and to prohibit certain activities in the zones. If you look at the legislations in the Australia and New Zealand, what is stated in 22 within brackets 2A to G, H are identical. Unfortunately, the Supreme Court took out the position that this has to be passed by a special majority. So therefore, we are compelled to drop that section and to park it for a later stage with regard to the areas what the TRC and the committee can prohibit the activities such as bottom trawling, the fishing line that is designed to catch fish or near the seabed.
So you won't have the power to do it?
We will not have the power to do it.
Okay, let's for a later date.
That's what.
Okay, what else?
Public commotion, there was another issue with regard to using the telecommunication system for the public commotion. The Attorney General gave an undertaking that we will not move with that amendment.
Okay. Then in that case, hold on a second. In section 17, You know, the Supreme Court has been rather harsh, vague, overly broad, some of these things. So you have made sure that you have made them precise.
Yes.
And no longer vague. And infrastructure and services, you have made the difference, right?
Infrastructure and services, we brought a committee stage amendment.
You bring a committee stage amendment on that?
And for that, the Supreme Court is in agreement for that.
Yeah, I think we need to move on. I would only flag one thing, that when you are at the committee stage, the consultation need to be also taken into our online bill. If there are any area that will be contradictory to this. For instance, using the online facilities and other providers for anti-state, not governmental state, people can critique the government, but anti-state matters, particularly about terrorism and other security issues, I would suggest, I'm not in the committee, so please make sure that that area not been clashing with each other.
I have another technical question on clause 35A and 35B. Is it an oversight, or is in 35A it requires local authorities, public corporations, etc., providers in sharing infrastructure for telecommunication services as per rules? And I thought you said earlier that the Supreme Court determined that rules need to be made into regulations and with parliamentary oversight. And in the same thing, in 35B, it says allows the Commission to direct operators to share facilities. Is it facilities or is it infrastructure? Are they oversight?
Clause 33, the Supreme Court had taken up the position, it's vague.
Or 35?
Sorry.
I'm referring to the term rule, because earlier on, I think 17A and B, rule was changed to regulation. And also facilities was changed to infrastructure. So I'm asking whether this is an oversight, it's an error.
Please bear with me, sir.
Those were competition regulations and infrastructure.
Yes, yes. May I explain to the Honorable Tribunal, the Supreme Court, Honorable Committee, the Supreme Court held that they want us to delete the 68(1)(a)(c) for the making rules for the management of radio frequency spectrum, and B for issuing guidelines from time to time which shall be adhered by the operators, provider or licensees. Only the Supreme Court has approved to formulate code of practices applicable to respective operators and providers. So only a code of practice can be...
No, that is not my question, Mr. Ahmad. My question is, in 35A, the word rule, as per the rules made under this act. So I'm asking whether it is an error that if it was changed to regulation, right? Because what is the power you have to make rules? Because earlier they said, look, you don't have the authority to make rules, it got to be regulations.
No, sir, we have authority to make rules.
I know.
Either regulations or rules.
Correct.
But sections, when it comes to section 17, particularly Supreme Court asked to change that to regulations, not the rules.
So I'm asking you, in 35 also, 35A and 35B, is it necessary, clause 24, right? Is it necessary to change it from rule to regulation?
No, not necessary, sir. The Supreme Court was not, that has not been...
Honorable Chair, I mean, I am neither a telecom engineer or a judge of law. We are here supposed to look at the financial benefit at the commandate. And I think Honorable Dolewata had very clearly said, this is one instant that we are surrendering to the Supreme Court as against the accusation that we have. So let us, with good faith, just go ahead with this and say our Supreme Court is capable of understanding, and our engineers and professionals are able to understand the interest of the state of Sri Lanka and the industry. මොකද අපි දැන් ওই ප්‍රශ්න ඇහුවයි කියලා ටෙලිකොම් ප්‍රශ්න ඇහුවයි කියලා ඇත්තටම දැන් බලන් ඉන්න කට්ටිය hina වෙනවා මේ රාගවන උඹ කොහෙද යකෝ ටෙලිකොම් ගැන දන්නේ උඹ නිකන් ගිහිල්ලා තදේ වගේ ප්‍රශ්න අහන්නේ මිනිස්සුන්ගෙන් කියලා my son has just texted me and said what are you talking about telecom when did you get a degree in telecom
no, I mean it's up to you. I mean it's up to you. I mean we are going through this process in good faith.
Yes.
All right. I mean if you
so
want
raise
to
the questions that are financially important.
No. I mean if you want to terminate, I mean if you want to leave, you are free to leave. I mean we are
if we all leave
no, I mean come on, you know.
So that's what we are asking.
Yeah, I mean, let us be professional about this. I mean, we are not asking wayside questions. No, we are asking questions that are important. If you gentlemen think it is not, then you are free to leave. Then this clause 32 about offence sending harassing messages using a phone. Publish someone's phone number to annoy them. What does that mean?
The situation has arisen. They are earlier under the.
Are you free to leave? No, so you can leave.
Honorable Sir, in terms of the original Act number 25 of 1991, the same provision was there for a telephone,
we have other things to do.
but not for the messages, WhatsApp and the SMS.
Yeah.
So we only introduced to cover that, and the Supreme Court considered the same issue, and they have approved for us to proceed accordingly.
Chairman and DG, thank you for coming. I have to leave now because 17 universities are closed and they are on strike. Regularly I am called for meetings, so Honorable Chair, if you excuse.
You are excused. We have a little bit more and then we will be done. Now, I have a general question. Now this bill expand digital services. How will this bill as a whole, right? How will this bill as a whole sort of reduce tariffs, market prices? Will competition sort of hopefully in the future prices will come down because of this, or what benefits will the consumers get with this bill? That's a general question.
With regard to tariff, we are introducing wide powers, so it will be down the line only when we are approving, and it will be cost based, and down the line only we'll have to ensure that. But in general, like all those amendments were made to ensure the quality of service delivered to the people, and have effective and efficient spectrum management, and ensure the competition. Like,
so let me be very specific. Now, DG, you said that the towers can be shared now, right?
Yes.
So that means the redundancy in that cost will be removed, no?
Yes. So connectivity will not be
So how will that be enforced? How will you make sure that if I have significant market power, let's say I am the dominant player, I have 60% of towers, right? 70% of towers. How is that person with 5% market share equitably and with affordable payment access those towers?
That is already done, sir. We have done through the infrastructure sharing regulations. Now, that is also part of the World Bank consultation that we have developed with the ITU also. So, we got the consultation and we have already developed the infrastructure sharing guidelines with the rates, everything.
Give me an example.
Yeah.
Now, let's say there is a small player. They want to access the entire infrastructure of the big player. Now, if you think about it, that is capital cost, no? So, if I want to build a network of towers, I have to put towers all over the country, right? So, it costs a lot of money. But now you have to share that infrastructure with a small player. So, the dominant player might say, why do I have to share the infrastructure with you? You pay me some exorbitant amount that the small player is not able to afford. How will that work?
In terms of the industry, the request from the industry was to allow us to share the infrastructure, first thing. So, secondly, we have addressed in the infrastructure sharing rules and regulations. So it will be cost based. So like we are not like we are not straight away saying to like share it without any charge or whatever. So that will be cost based. So now we concluded that process. We got the inputs from the operators and we evaluate it cost based, and then only we approve the tariff which will be shared. Like
I guess they say the evidence is in the eating, no? So I mean, has sharing begun in a big way?
May I be permitted to bring it to your Honorable Chair's notice? In fact, Sri Lanka Telecom instituted 2 writ applications in the Court of Appeal seeking a writ of mandamus compelling the TRC to permit radio access network sharing with their subsidiary Mobitel. And thereafter, the Honorable Attorney General got involved in the matter, and there were 4 cases which were filed, and the RAN sharing was entered as part of the terms of settlement between all operators. And the same provisions were incorporated into the amendment. And the broadcasters came and challenged before the Supreme Court the RAN sharing arrangements. However, the Supreme Court has permitted the RAN sharing, so radio access network sharing. So I think that will address your question, because that will be a very progressive step in order to reduce the cost.
Okay. I think any other questions, honorable members?
No. If you are wrapping up, it's good that I was about to leave.
No, you
then
can
of course
stay,
I'll stay. Yes.
You know, I take a lot of effort, and my team we study these pieces of legislation. We don't come here just to take you through some 15-minute joyride and let you go home saying everything is okay, right? So that is what all members here do. We in fact study this and we share with every member. There are how many members? 20 odd members and 24 members, 27 members. Generally the members who you see here are the ones who participate. So as a legislation, or as a committee that goes to such legislation, we want to make sure that the mistakes we made in the past are not made again. We are all talking about good governance and the need for oversight. So that is what we are doing. So sometimes people get very upset or they are jittery, but that is not the concern here.
Chairman, I don't think that my fellow members had that feeling, because they have already discussed, and once they have come to a conclusion that we are giving the safe path towards the parliament.
I'm just taking
just like once we are satisfied with the whole process, that's what I think they have left the premises.
I'm taking the prerogative I have as a chair to make some comments, and those are the comments I'm making. So that is why we are trying to go through this. That is why we are asking these questions, to ensure that we have a better deal in the future. And particularly telecommunications, the legislation that governs technology is going to be absolutely critical if you are going to drive this economy's growth. So once again, we thank you very much for your participation and your eagerness to answer rather complicated, sometimes irrelevant questions. Anything else you want to add?
Nothing, sir. Thank you.
One moment. Yeah, I mean, what my secretary is showing is that this has to go to the SOC on technology. Have you been to the SOC on technology, Mr. DG?
No.
I think we can, before taking to the parliament, we can take the report. Chair, I think before presented to the Parliament, we can go to the SOC.
Yeah, we were under the
have the
impression
report,
that
yes.
we were under the impression that without referring to the SOC only, they referred to the public finance.
You need to check with the government whip.
Okay,
Yeah.
okay,
Right?
we'll check it. We'll check it.
Check
We'll
with
check
the
it.
office.
Okay.
I mean,
I was told by that office, like I was
Yeah,
also
because
asking why there is public finance. Like I was under the impression that it will go to the technology SOC.
Yeah.
But they told me that like it is referred to public finance.
So this is the first time. That is why we also took a little extra effort.
Yeah.
Because I'll tell you why it has happened. Because you're a senior government official and the AG's office is here. Is because of what happened with the outsourcing of the online visa matter. Now that was an issue with respect to changing visa fees.
Yeah.
And while changing visa fees, there was some additional fees that got brought in. So it is a matter of public finance, the change in the levy. That is why it should have come here, but it didn't come here.
Yeah.
So after that matter, everything that has levies and fees come here. So this is the first such instance that it has happened. So I don't really know whether it needs to go to the SOC.
That's what they told, sir. That's what they told.
Yeah, but I differ. I think it has to go to the SOC. Maybe I'm mistaken. Maybe you should check it with the parliamentary office, because the note that we have got, it gives what is called a list of subjects and functions, and under the Ministry of Defence, TRC is listed, and under the Ministry of Technology, where is it? TRC is listed. I don't know why the TRC should be listed under two ministries. It should be listed under one ministry, if at all. And I would think it should be technology, if at all, because we are dealing with technology. So I don't see why you should be...
So it might be a mistake, because earlier it was gazetted under the Ministry of Defence.
Yes.
And recently it was brought under Ministry of Technology.
That's
So
right.
it
So I
might
think
be
this is a mistake.
a mistake.
I think they need to update this, because no institution can be gazetted under two ministries. Yeah. Okay, so that's up to you all to resolve. From our end, once again we thank you and we wish you all the best in getting this done. Thank you.
Thank you very much, sir. We too wish you all the best.
Thank you.
Thank you very much, Chair, and the members and the staff. Thank you.